Today we're going to discuss about if you're being terminated on job, if you're on H-1B, what are the options that you have? Stephen, what's going on? I mean, in the tech layoffs right now.
Yeah, we've seen three major tech companies, Meta, Amazon, and Twitter, already announce massive layoffs that would impact tech workers. And we've seen stories from the national media that these are impacting H-1B and other non-immigrant visa categories. With the recession coming, Rahul, I think this could be impacting other companies as well moving forward.
Yes, and we're hearing rumors Microsoft may be also in line to lay off. They have not officially announced it. There are other companies that are coming in, and especially for Robinhood and some other companies also started laying off though. Now, we're going to discuss about if you are on H-1B, if you got laid off, what are your options that are there? Now, do they have what is the 60-day option? Can you explain, Stephen?
Yeah, so I'm going to preface this first off with, we're going to talk mostly about H-1B. I think it's easier to discuss one visa category. But the 60-day grace period is allowed for E, H1, L1, O1, or TN visa holders and their dependents. So in regulation, there's a 60-day grace period that allows the individual to be considered essentially as maintaining their status for up to 60 days once there's what's called a cessation of employment.
What if my I-94 is only expiring in December 1st and I got laid off right now? That is on November 15th. Let's say November 14th. November 15th, I got laid off. So do I have the 60 day even though my H-1B is expiring in December 1st of 2022?
No, the way the regulation is written, it's 60 days or when status expires, whichever is earlier. So in your instance, your grace period would end December 15th when your I-94 expires.
What if I'm getting laid off right now on November 15th, but I'm going to get paid until the end of this year? What are the options at that point?
Yeah, I mean, we've tried that argument before with mixed success, but the way the regulation is actually written is cessation of employment. So when the employment ends and when you're terminated, when you're laid off, that's the date that I would use for calculation, not your severance pay or anything like that.
You said to us that in the 60-day period, I can move to a different company, especially on H-1B. And what about if I want to move to a different status? For example, H-4 status. Can I move to H-4 status?
Yes, yeah. You could either change H-1B employers or change your status.
What about moving to B-2 or F-1 status?
Yeah, absolutely. So the one thing to keep in mind with both of those is that they're going to be pending for a long time. I know there's some people that they'll kind of use that B visa to bridge the gap into a new H-1B, and you may see some status issues with that new H-1B or have to consular process it. But B visas, F-1, H-4s, all those are available for you. Any non-immigrant visa classification.
Is it, when I see the regulation, it says that it's a discretionary for the USCIS to approve the 60-day period. Do you see any problem in implementing, USCIS implementing the 60-day?
No, I mean, we saw some issues early in the Trump administration with some very liberal interpretations of what we saw as cessation of employment, denials. But, when we're talking about layoffs, when we're talking about firings, we're not seeing any pushback on the 60-day grace period or denying those.
What if my perm is approved with my company and now I got laid off? Can I take this perm application, file an I-140 with a new company?
No, unfortunately, that perm, it's only for that employer. So you're going to have to, either get them to sponsor you, which may be difficult when you're terminated, but you can't use it. Now, let me ask you, Rahul. I'm not laid off. My perm is pending or it's approved. What are my options in that situation? It's still pending. Let's start there.
Even though you did not get laid off by the big company that you are in right now, but if they have another layoffs, you may have a problem, Stephen, because they may not be able to approve the labor certification. Even if the labor certification is approved, the companies may not be willing to file the I-140 application. Especially, this is a big warning for all the people who are on H-1B who never got their I-140 approved, and you're working for a company that recently had a massive layoffs. They may have a problem in filing the perm labor certification. And the reason why they may have a problem in filing the perm labor certification is that in the perm labor certification, the employer has to prove there is no American worker available for the kind of jobs for which they want to hire you permanently. And especially when there has been a massive layoffs in that particular department, and they are telling that there are no jobs for the US workers, they may not be able to file the perm application. And if the perm application is in between, the Department of Labor may deny it, saying that, hey, you're having layoffs. How are you telling there's no American worker available? Even if the labor certification is approved, the companies may not be willing to file an I-140 though. So people who have not been laid off also, you may want to consider whether you want to stick with that company. If you, especially if your labor and I-140 has not been approved, you may want to consider moving to a different company where there will be no layoffs so that they can file the POM labor certification approval. We have seen this so many times. This happened in 2000 and 2001, Stephen. This happened in 2008 and 2009. In between, the companies will start laying off and they may not be able to file the labor certification. And that becomes a problem for the people who are nearing to 6 years.
And I mean, even with the ones that, let's say they happen to be able to still go through, with the long processing times, we'll probably even see an increase in audits, right,
Yes.
for these companies. Even, and if it is able to, the company does want to continue, we'll see more.
Yeah,
audits.
most of the companies, they don't want to get into audit. They normally
Right.
withdraw the application. And then when the time becomes better, when they start hiring people, then they will start filing the I-140 again, labor and I-140 again.
Of course.
Now, what about those people whose I-140 is approved? What can they do?
Yeah, so the good thing is that the moment your I-140 is approved, your priority date locks in. So you get yourself in that line, especially, for an Indian national, you can get yourself in that line that's the secondary line. After 6 months, you're what we call fully vested in the I-140. So even if the company withdraws it because they've terminated you, you can use that I-140 after 6 months that it's been approved to get extensions beyond the 6 years for your H-1B. You can get your spouse the H-4 EAD. You become fully vested after that 6 months.
What if I have only used up 3 years of H-1B, Stephen? And now I don't see any hope right now. I don't want to stay in this country. Can I move to India? I only used up 3 years of the H-1B out of the 6 years. Can I move to India and stay there for 6 or 7 years and come back again without subject to the lottery?
Yeah, so the regulations are, fairly young on this. I mean, when I say young, I think within the last 5 years. But once you're counted against the H-1B cap, you're always counted against the H-1B cap. So theoretically, you could go back to India for 5 years, 20 years, whatever, and always be counted against the cap the way the current regulations are. Now, of course, I wouldn't recommend 20 years.
One caveat is that if you used up the 3 years and you are going to India and you're wanting to come back again, though, you will not be getting the entire 6 years if you don't go through the lottery system. You'll be only given 3 years of H-1B. That means the leftover of the 3 years of the 6 years, you can come into this country. Now, obviously, if you have an I-140 approval, as Stephen has described, you don't have any limitation. At any point of time before you die, you can always come back if you have an I-140 approval, which is not withdrawn in the first 180 days. You can always come back at any time. A lot of rumors circulating to us saying that, oh no, since the H-1B validity is over, you cannot come back. It's only valid up to 6 years. No, there is nothing like that. You can stay outside the country for a long period of time and you can come back at any point of time. You will not be subject to the lottery. Anything else here?
No, I know. Layoffs can be stressful for anybody, whether you're a U.S. worker or on a non-immigrant visa. But with non-immigrant visa holders, you obviously have different issues because your immigration status is at stake. These are just some of the questions that are common. I posted an article on our firm's website with more questions, and always feel free to contact one of our attorneys if you have specific questions about your 60-day grace period issues.
I want to address the order of preference that I would be handling it if I were you, if I got laid off. The first option would be that if you have an option of going to H4 or L2 in your particular case, so that is the best option. The reason is that it's a long-term non-immigrant visa. No, not many questions are asked in it. You normally get those things approved. You can file it immediately and you can file within 60 days after you get unemployed. But it should be filed before your I-94 expire or 60 days after you get laid off. Please remember that it's the day you get laid off, not the day your last paycheck is. So if you get laid off on November 15th, So the 60 days will be somewhere in January 10th or January 12th, somewhere around that period of time though. It's, let's say if you're getting paid until December 31st, you do not count 60 days starting from January 1st. It's the day, your last working day, which would be November 15th. Now, the second preference probably depends on do you think so it's going to be temporary that you are going to stay in United States? For example, you just got laid off. 60 days may not be enough for you to sell, dispose of all the things and move back to your home country. Then you may want to consider B1, B2 options, temporarily stay in the United States to dispose of, to do the necessary things to move on. If you think so that, okay, no, I'm not going to go back. I want to stay here for a long period of time to think about, to see what I want to, and probably in the meantime, I want to study though. You may want to choose an option of F1. That's a very good option that you can think about. I would also suggest though, now this is too early at this point of time. Everybody is using the word recession, but I don't know how many people know what a recession is. I've been through, as an immigration lawyer, I've been through recession 2 times. One in 2000, 2001, one in 2008 and 2009. Recession is bad. I mean, it's very bad. You won't get any jobs. It's very hard to get jobs, especially for tech industry. Now, for those people who are in the consulting though, it's very hard because the consultants are first to be kicked out. Then comes the employees though. So it may be very hard. I want to keep the option of leaving to India and coming back. It's not that bad because if you stay here in United States, you are not working in United States. You may be bleeding a lot of your money and your resources. So it may be a wise option for you to think, I'll just go to India and come back. I mean, at the most, your airfare and certain other things. So have the option of going back to your home country and coming back. You may also look very good in front of the consulate. Let's say you got laid off from a company called Meta, and then you just leave to India, and then you stay after 2 years, everything turns around, and then you come back. You look very good in front of the consulate when you approach for the visa. If you are lingering around here on a B2 visa, or if you are lingering here on an F1, and then you again try to go for a H1 visa, the consulate may be very reluctant in granting you the H1 visa. Now, H4 is quite a different, strong visa. L2 is a strong visa. It's perfectly fine. You don't have to leave, especially when your spouse is working and earning the money. But F1 and B2 does have some deficiencies though. There are other questions that comes out, Stephen. Let's say, for example, if I apply for F1, okay, I got laid off with Meta, I applied F1, and F1 is taking about 14 months now.
Right.
What if for 3 months down the line, I got a job? Can I move back to H1B? How does it work out?
Yeah, so my recommendation to people is to give it a shot. You're not technically in status because your 60-day grace period is expired and your F1 is still pending. You're in a period of authorized stay, but you're not in status. So I always tell people we could try to file the change of status from the pending F1 to H1. Your worst case scenario, they'll approve the H1B with consular processing, which is about where you'd be at if you didn't do that. So it's worth the gamble and ask them to maybe adjudicate the F1 and then immediately adjudicate your H1 in that scenario and get on the H1. And let me ask you, Rahul, one of the topics before I forget that you had just brought up, moving back to India. And, a question I get asked a lot is, I'm going to go back to India, but my U.S. worker wants me to work from India. So I don't have H1B status, but they want me to work from India and for my U.S. employer. Is that okay?
Perfectly legal.
Yeah.
A lot of people ask the question, I don't have a work permit to come work for a U.S. company. Well, if your butt is sitting in India, you do not come under the U.S. laws. And right now, the U.S. government, the Indian government, and some other countries, most of the governments, are all the governments that I know about, only count where your butt is sitting. So if your butt is sitting in India, you are an Indian citizen, you can work. It doesn't matter whether you log into Mars, whether you log into USA, you don't need any work visa if your butt is sitting in India and starting working. For the people who are on the student visa, you said, when I apply for the student visa after 90 days and then I apply for H1B, can I start working as soon as I get the H1B?
No, that's a good question. No, because in that situation, you're not on H1B, you can't use the portability rules. You'll have to wait for that change of status to H1B to be approved before you can start working on H1B.
Is it the same case if it's a B2 or a H4 also?
Yes, yeah. So any of those other visas that you've applied to, H4, B2, F1, and to kind of bridge that gap, you'd have to wait for the change of status to be approved before you start working on
And
your
you
H1.
said that there are very good there are chances it may be approved change of status. It may not be approved. You said you at the most they will still give you the H1 approval, but not with the I-94. Then when I get the H1B without the I-94, can I start working?
No, if you don't have the I-94, you're going to have to go consular, process your H-1B, go for stamping, come back in. But the reason I always recommend it is it's low risk, high reward. You're not working, so you're not violating any non-immigrant status. You're asking them to, hey, approve my F1. I'm putting down that my status is F1 pending. I'm giving you that receipt. And I'm asking you to approve that and then immediately put me on H1. And if it works, great. You get the change of status to H1. If it doesn't, you got a consular process, which is your only other option.
So you need to evaluate properly. What Stephen is telling is to move on to F1, H1, or B2 because there may be a very good interruption of work for you, though, even though you got a job with a new company. But if you go to India, though, you don't have to stop. I mean, let's say, for example, 3 months down the line, you get a job. Can you be on the job immediately without even getting H1 approval? Absolutely. When you're in India, you can. And you can come here once the H1 is approved, stamp there. But in the case scenario of you going with the option of F1, B1, or H4, you cannot work and until the H1 is approved with the I-94, and if the H1 is not approved with the I-94, then you have to go and get the stamping. So the whole process for you to start working for a company may be delayed. So you may want to consider both options to see which one will suit to you, to your needs, and particularly the company that is going to hire you. If they want you immediately, maybe India is a better option.
And I just want to say, I know we're talking about traveling back to India and changing status. You can always, during that 60-day grace period, find another H-1B employer. If they're willing to sponsor you without any gaps in employment, you file the transfer to them and you can start working once it's filed. These are your options. Like Rahul was saying, with recessions, it may be difficult to find. What are your secondary options?
One of the other things that I have, Stephen, is that what if I have a passport visa stamping with a Meta company until 2024 and I got laid off right now? Let's say I go to India and I get a job offer from Apple in 2023 February. Can they file H-1B? Do I need to go to stamping to come back into the United States, or can I use the Meta's H-1B to come here even though I will not be working for Meta?
Yeah, as long as you haven't overstayed or violated the terms and conditions of your H-1B, the recommendation I have would be just to take that Meta visa stamp, the new Apple approval step out, and come right back in to activate everything, so to speak.
So even if I'm in India, I don't have to go for stamping.
Correct. Yeah, and I think we've done a video on that a couple months ago about all these different when jobs change with your visa. We'll put the link in here as well.
That's true.
No.
Thank you very much. Wish you best of luck.